I I was browsing YouTube and I came by that video, which I believed it will be beneficial to comment on. Um, it is actually I found it on Toronto Sun um, channel on YouTube, and in this video, the Ontario Premier uh, made various statements that I believe need to be addressed and dealt with. Uh, these statements need to be made and broadcasted in the media. Um, in my view, actually, they reflect a deep uh, problem in the justice system in the province, which need to be responded to. So I will. It's a very short video, and I'll respond to the points that the Ontario Premier raised in this video. So let's take a listen.
People are getting out on bail, and then I'll report back to you, because something tells me a lot of them are going to be back out on bail to recommit the crimes.
So Mr. Ford is concerned about the bail, the people who get out on bail, and then commit the crimes, and who get bail 4 or 5 or 6 times. Then after the release on bail, they commit more crimes and get arrested or not, but they just commit more crimes while waiting for the trial for the other offenses that they allegedly committed. I mean, the offense that they are accused of. So that's his concern. Let's keep listening.
Morning, Premier. It's Jessica from the Trillium.
Hi, Jessica.
I'd like to follow up on your comments about measuring bail. It sounded like you were implying that JPs and maybe even some judges are letting people out on bail too much. If that's what your statistics tell you, will you remove them from the bench?
Here we see a reporter who's asking Mr. Premier about um, his previous statements, um, and she's suggesting that he's not happy because um, some judges and justices of the peace would let people out on bail too much, and she's asking him if he has statistics for that and things like that. The approach to the matter, I mean, for a matter like this to be dealt with in the media, I don't believe this is a proper question to ask, um, because apparently the reporter is. I mean, it could be. I mean, it all depends on how you approach the question, because it could be that the statistics, the fact that people get bailed too much, it's actually it's their constitutional right. No person should be denied bail without a just cause. That's not how it should be asked, because if a person got bail uh, with certain conditions or without any conditions, it all depends on the judge's ruling. Uh, it if somebody thinks that the judge is ruling that a person was released on bail uh, unjustly, then the Crown and the defendant's attorney, of course, have the right to appeal the judge's decision if they believe that an error of law was made. Uh, According to the law, a person should be released on the least onerous conditions if the conditions were found to be enough to address the concerns of the prosecutors. or to be detained if the judge believed that the conditions like don't address the concerns that the prosecutor is raising. If a criminal attorney believes that an error of the law was made by a judge, they always have the right to appeal to the next level of the court and explain why the judge's decision was wrong and support that with evidence and request the remedy they believe to be appropriate in the circumstances. For instance, if a judge released a certain accused on like a certain number of conditions or so, or certain conditions, and it all depends on the prosecutor's position. If the prosecutor, and it's all like every case, it's very case specific because the circumstances and the facts for every case are different from the facts and the circumstances of other cases. I mean, they are unique. Every case is unique in its facts and findings. So for a crown attorney's position, if a crown attorney, for instance, requested the detention of the accused or consented to release on certain conditions, they have to explain why certain conditions should be imposed and why an accused shouldn't be released without the imposition of these conditions, or why the accused shouldn't be released at all. In Mr. Ford's statements today, I believe he is referring to certain persons who are apparently dangerous offenders, who are people who have no respect for the law. So people who pose a danger to the safety of the community, which is the secondary grounds, because according to the law, a judge should actually a detention of an accused in custody is justified only on one or more of the following grounds. The primary grounds is where the detention is necessary to ensure the accused's attendance in court in order to be dealt with according to the law. And if the Crown attorney raised this ground, they have to prove why an accused should be detained on this ground. And here as I can see, I see that the Premier is actually raising the secondary grounds, which is where the detention is necessary for the protection of the safety of the public, including any victim of or witness to the offense or any person under the age of 18, and having regard to all the circumstances, including any substantial likelihood that the accused will, if released from custody, commit a criminal offense or interfere with the administration of justice. And of course, the tertiary grounds, if the detention is necessary to maintain confidence in the administration of justice, having regard to all the circumstances, including the apparent strength of the prosecution's case and the gravity of the offense and the circumstances surrounding the commission of the offense, including whether a firearm was used and the fact that the accused is liable on conviction for a potentially lengthy term of imprisonment, or in the case of an offense that involves or whose subject matter is a firearm, a minimum punishment of imprisonment for a term of 3 years or more. So let's deal with the secondary grounds. Let's first take a listen at what the premier said, and get back to the law and how this issue should be addressed.
Well, let's first measure. We can't measure. There's no measurement going on right now.
You see, that here he's making a very good point. He's saying let's first measure. There is no 1 second here.
There's no measurement going on right now.
There is no measurement going on right now, and I agree with him that there is no measurement going on right now because the standard of measurement is lacking. And the standard of measurement here should be whether there is an error flow that was committed or that was made by the ruling judge. If there was an error flow, the Crown always have the right to appeal. And actually, I would say that the Crown must appeal it because the Crown is responsible for the safety and the security of the public. And if they didn't actually appeal, that means that they're not doing their job. So for the secondary grounds, the measurement, he's saying there is no measurement right now. That's true. And I would say that this because, and that's from my experience, this because of the incompetent and inefficient Ministry of Attorney General and the lack of understanding of the law by the Crown Councils, and I would say even by so many judges, including judges in the Court of Appeal, who make so many errors of law, and that's why we are facing this issue that Mr. Premier is raising. So there is no measurement because the Crown apparently doesn't understand what or the Attorney General in general. And I'm not speaking about everybody because there are some Crown attorneys and some lawyers in general who are very competent. And I'm not speaking about these lawyers. I'm talking about the lawyers who fail to understand what an error of law is and how when a judge fail to make a correct inference based on the facts, and if a judge failed to consider a part of the evidence that contradict another part of the evidence, and this actually impacts the outcome of the judge's decision, that this is actually an error of law. If a bail judge failed to properly consider the risk factors that were proven by the Crown, for instance, which pose a real threat to the safety of the public, and still released the accused without having like the measures or putting certain conditions that would guarantee or significantly mitigate and address all the risk factors that are advanced by the Crown, and the judge still made that error, that will be an error of law, which should be addressed, and the Crown should appeal the judge's decision to the appeal court, which is the next level of court. In this case, the Crown always have also the right, in accordance with the applicable case law. If the Crown sees any grounds for reasonable apprehension of bias that justifies a harsher decision to be made, which could be like removal of a judge or so for based, for reasonable apprehension of bias, or where they believe that the judge is incompetent or so, they can always make a complaint against the judge to the board for the judges and the JPs, to the provincial board, or for the Superior Court judge to the CIC, to the sorry, I'm not sure. Is it the CIC? No, it's not. So 1 second. There is Judicial Council, Canadian Judicial Council, sorry, to the CJC, and explain why a judge should be removed or why a judge should be sanctioned for a certain decision that the judge made. So these are the legal pathways that should be actually pursued by the attorneys against incompetent judges when the attorneys believe that the judge made an error of law and that should be reversed, and or asking for sanctioning the judge by imposing a certain penalty on them, including having them removed from bench. Let's keep listening.
I love our court system. We have some of the finest JPs and judges in the country.
So, and I see here, Mr. Ford, I believe this is a naive statement to make. I mean, he is saying he loves the court system. I mean, which is it's a part of the administration body, which is the government, and it has certain tasks to accomplish. So it's not something that you should love or hate. It might be like he is reflecting that he has like positive impressions about his justice system, and he is indicating that Ontario has some of the finest judges and JPs, and I wouldn't disagree with that, but I would say that from my experience that so many judges and GPs in Ontario are very disqualified. So many crown attorneys are very disqualified. So many police officers are disqualified. Many of them are incompetent. Many of them are biased. Many of them are dishonest. So we have true problems here. Many of the cases are decided politically. So for him to come up and say, "Oh, they have like some of the finest judges and GPs," this is a very controversial statement. That, in all honesty, I wouldn't. I don't want to comment too much on that, and I would like to be more focused on the core of his arguments and the problematic statements he made, or how they should be addressed in order to deal with the concerns that the government has at this point when it comes to the release of dangerous people on bail.
But we have some other JPs and judges that just think letting him out on bail.
And you see here, because of Mr. Ford's ignorance on the law, because he's not a legal professional and he didn't study the law, he doesn't know the law, and he didn't read about the law. He is believing that okay, when a judge when he's making it very subjective. When he speaks about certain judges and GPs who decide, okay, let's have these people released on bail. That's not how it works, Mr. Ford. There is a law. There is a law. And when a judge decides to release someone on bail after they hear submissions from both the prosecutor and the defendant, um, when they grant bail, which is a constitutional right, if they found that none of the three grounds were proven by the prosecutor and grant bail to the accused, they are actually giving them their constitutional right. If the Crown is dissatisfied because they believe there was an error of law, they can definitely order the transcript of the bail hearing and highlight the error or the errors of law that were made by a certain judge. They can appeal the decision, and the respondent has the right to respond to the Crown's concerns. And that's how appeals work. That's how, like, the law is there, and that's how the process should move forward. So for Mr. Ford to come up and say, oh, there are some judges and JPs who just give people bail, give people their constitutional right, it's because of Mr. Ford's lack of understanding of the legal foundation of how bail or the case law regarding how bail should be granted, and what the Crown needs to prove, and how the judge should decide. It's because of his lack of understanding of all these matters that he's making these reckless statements. When he comes up and say that, oh, there are some judges and JPs who just let people out. That's not how it works. That's not how it works. If you have a problem with a certain decision, Mr. Premier, a certain judge's decision, your attorney general should come up to you and say, "Hey, Mr. Premier, we have this issue here. We believe that this judge made this error of law, and we're appealing this decision on the following grounds." And they start to explain that to you, and you come up and tell the public in a media release or write, because I see that you write articles sometimes in the newspapers or so. You start like making your arguments or explaining to the public why you're taking this position from a certain judge. But to come up and just generalize and make very vague statements without the correct regard of the applicable law is something that I find to be reckless.
This is the right thing to do. It's the wrong thing to do. But we're going to be measuring, and there'll be accountability. Like, I get held accountable.
Okay, which is good. I mean, here he is saying that they're going to be measuring, and there will be accountability, which is something that I completely agree with. So wherever Mr. Ford believed that there were errors of the law that were made, the Crown has always the right to appeal. The problem is, from my experience, I found that the Superior Court, even the courts of appeal in Ontario, they make grave mistakes when it comes to the dealings with the errors of the law, because even the Superior Court judges and the Court of Appeal judges make very, like, not even naive. I mean, yeah, I mean naive mistakes and very basic and clear mistakes when it comes to the uh, errors of the law. And these mistakes reflect actually uh, clear incompetence of these judges. So the problem now is, even if you first, Mr. Ford, uh, understood what is the standard of measurement, what the standard of measurement should be, and you made a correct assessment, and you decided to pursue um, and follow the process, um, you have a problem with court judges, with appeal court judges in the courts of appeal, who are very subjective, who have a very high level of bias, uh, and who are very incompetent and who should be removed from bench and should have been removed from bench. But because the CJC is so corrupt, and because the board that reviews the judges, the provincial judges' conduct is so corrupt too, and because the um, what's it called? Uh, the Lawyers Association, Ontario. Let me find it. Ontario Lawyers Association. The Law Society. Yeah. The Law Society of Ontario is so corrupt too. Very subjective, and very incompetent, and that actually makes your task even more difficult, because there are major concerns regarding the integrity of so many lawyers, so many judges, so many justices of the peace in the province. So the integrity and the competence of these people, and whenever a person files a complaint against them or try to get the wrong corrected, they fail because of the lack of integrity and the lack of accountability for these people. So I hope like this input actually can help you with your pursuit, which I believe is driven by good intentions and is being done in good faith, which is preventing the dangerous offenders from getting bail, and because of the risk that they pose to the safety of the society.
Like the chiefs getting held accountable, the court system has to be held accountable.
Okay, that's good. So now you're saying that because you should be like held accountable for any wrongdoing that you may make, and that officers should be held accountable, then the court system should be held accountable. In all honesty, I don't believe there is any accountability for you to begin with. I don't believe there is no accountability. There is accountability for the corrupt lawyers, the corrupt police officers, or the corrupt judges in the justice system. When you say the court system should be held accountable, this is I would say another reckless statement that you're making, because when you say this actually can be misinterpreted by some people who would say, "Oh, the court system, is not good. It should be held accountable." It would have been better if you said that the incompetent judges or the corrupt judges should be held accountable. I would have agreed with that. But to say that the court system should be held accountable. The court system, by the way, includes the Supreme Court of Canada. All right. So this is a very, this is a big statement to make. And if you're making this statement, it should be supported with facts, supported with evidence, and you should be more specific rather than generalized in your statements, Mr. Ford. Uh, because to make these statements in the media and, the public are watching it, the premier is saying, okay, the court system should be held accountable. All right. And the people actually are supposed to have trust in this court system.
Paul, could you explain to us exactly what that accountability might look like? I think some lawyers might have some concerns about the independence of the justice system under something like that.
Well, they're always independent, but who holds them accountable?
Exactly. And here, like, the reporter raised the concern that any member of the public would certainly have when he hears this statement by a premier who is trying to give the court system accountable. And then we observe here like deep ignorance of how judges should be held accountable. He says, who holds them accountable? Well, maybe you should actually ask some legal counsel about how a judge should be held accountable and what's the standard and what's the law in this regard. Instead of coming up on the media and showing how ignorant you are and asking this question, right? Because there is a system for holding a judge accountable, for holding a police officer accountable. There is a system, there is a law in this regard. Maybe you should review it and, make more mature statements in this regard.
How do you like someone banging in your door, put a gun to your head, and find out later that they're out on bail 4 or 5 times, and they're mocking the police in the back of the cruiser, saying, by the way, I'll be out on bail by the time you start your next shift.
And I agree with him. I mean, a person who manifests such conduct, that person shouldn't be free. A person like that should have been in jail and shouldn't have been out on bail. And this actually reflects a problem, a deep problem in the justice system. And I cannot speak to that certain case without having all the details about it and how, and the transcript of the bail hearing and the arguments that the Crown made and the arguments that the defense counsel made and why the judge ruled the release of that person. And so, but like what he's saying is completely unacceptable. People like that, people who are dangerous offenders, who are very violent, who get bail like that while they pose a threat to the safety of the community. So there are clear, provable grounds for the detention on the secondary grounds. If a judge, I cannot say that a judge made an error of the law without reading a judge of rulings. Maybe it was the Crown attorney who was incompetent, who made insufficient arguments or improper arguments or arguments that didn't convince the judge. So it could be incompetence on the part of the Crown attorney. It could be incompetence on the part of the judge. For Doug Ford to come up and say something like that, I understand he doesn't like the outcome, but the outcome doesn't have necessarily to be the fault of the judge. It all depends on how the proceedings unfolded and how, the prosecutor presented their arguments and what were the judge's grounds for releasing that accused. But I agree with the premier that the safety of the public is a paramount, and that any person who threatens the safety of the public um, shouldn't be granted bail, because this is actually one of the grounds that justify the detention of an accused. So these are the just causes that are indicated in the charter.
There has to be accountability at all levels, starting from the premier, right from the prime minister, the premier, and police chiefs, and the court.
Okay, good. So the prime minister, the accountability. I mean, we saw that. I mean, the injunction of the Emergency Act, and in which both you and our prime minister were involved in. So, but I also noticed that, and there's so many things. But Mr. Ford, I heard like a couple months ago, and I didn't take a deep dive in this case, but I heard that one of your employees or one of your officials were um, was found to have breached the public trust, um, and for you, instead of holding him accountable, you rewarded him by giving him another position for his dishonesty. So you're trying to get everybody held accountable, but what about you? I mean, this decision actually should have been held accountable for that decision, Mr. Premier. But it's I would say like there is systemic corruption, organized corruption in this province, and it's because of the corruption of the government. So which needs to be addressed and to be taken seriously. Uh,
Courts aren't exempt. They have to be held accountable for the decisions they make.
and this very, I mean, well, I can understand that in the general meaning that judges are actually uh, a, a part of the court. I mean, they are, when a court allows certain judges to be biased and just overlook uh, them and not disciplining them, then they should be accountable. But you see, the problem is that's not how it works. The courts are not the body that is responsible for, how can I say it, having or putting a judge to account. The bodies that are in charge of this duty are the judicial board, so the provincial judicial board, and the Canadian Judicial Council. So for you to say that who puts the court system to account, this is a very naive way to put it, which is, I mean, I understand is a result of your ignorance of how the law works. So everybody should be put to account, but you can't say you should put the court system to account. You should say you should put the corrupt or incompetent judge to account. That's the right way to say it. Instead of saying to put the court system in account, man, that's not good. Because you are raising concerns about the integrity of the justice system by saying something like that. I mean, I wouldn't even say that the whole court system in the country is corrupt. I mean, there is a lot of corruption, huge level of corruption, but I cannot say that the whole system is corrupt, because some judges are competent and some judges are independent, truly independent. And some judges are not biased. So I can't say I want to put them to account if they are doing their job. You see, but the problem is because of the lack of the competency of so many crown attorneys and so many defense attorneys as well, um, they just let so many errors of law uh, slide and never appeal them. And that's a huge problem that we have in the province. Like I said, due to the lack of competency and the corruption in the Law Society of Ontario and in the Judicial Board. So these are the issues that should be dealt with instead of just coming up and um, pouring your wrath over the whole court system. You should be more specific and you should deal with the problems, the very specific issues that caused this problem that you're raising here to manifest. All right. So that's it for today. 41 minutes. I hope I covered everything. And I hope that my submissions today to you were useful. Thank you for watching and have a good one.